He'll be giving the perspective or the South African perspective to this. Professor Stefan Barnett works as a lecturer at the University of Pretoria for the past 34 years. He has a wide experience in labor law and is also an admitted attorney. Stefan has served as president of the African Labor Law Society and is one of the founding members of the society. He has also served as a vice president, Africa region of the International Society for Labor and Social Security Law, and has been a head of the Department of Mercantile Law at the University of Pretoria. He has a wealth of knowledge in this area. He has also authored and co-authored numerous articles and books, and he is a C1 National Research Foundation rated researcher. So he's a top researcher in all respects. At this point, I really want to welcome Professor Barnett to give us his presentation on that end. I also, just for purposes of the webinar, if there are any questions you may have, you can drop them into the chat box. We will also have a session at the end of the webinar for any Q&As, but please keep all those questions and queries and even comments handy as we go through. Thank you. Prof, you may proceed.
Thank you very much to all of the delegates. I trust you can hear me well, and I'll be asking the hosts just to roll my PowerPoints along as we proceed. The title of my discussion is Unmasking the Mandatory Vaccine Mandate in South Africa. And just to place things in context, South Africa has got approximately 60 million, approaching 54 million, Lesotho 2.2 million, Mauritius 1.26. Now, South Africa had its first recorded COVID case on 5th of March. And shortly after that, we had strict lockdown procedures implemented in terms of the Disaster Management Act. This is a pre-existing piece of legislation that has been in place for a number of years. It's not workplace related at all. Now, up to date, we've had 3.7 million COVID positive cases, approaching 4 million, and sadly 100,000 plus deaths, and approximately 50% of the adult population has been vaccinated. Next slide, please. Now, initially it was only doctors and nurses who could go to their workplaces. The rest of us stayed at home, and the following questions quickly arose. What are the rights and obligations of employers and employees during this COVID pandemic? Also, may employers compel their employees to be vaccinated? As we know, many African countries had problems in, first of all, sourcing vaccine. But now that we've got the vaccines, and before they started transpiring, question was, could employers compel their workers to vaccinate? And then the last question is, if employers may compel workers to vaccinate, what steps may employers take should an employee fail or even resist the instruction to vaccinate? Starting point in South Africa is the Constitution. An employee cannot rely directly on the Constitution, but whenever case law is being interpreted, and also when new regulations are implemented, those must abide by, amongst others, the following fundamental rights: the freedom of bodily integrity of the person. That includes any medical testing on persons. So the individual has freedom to participate or not. Freedom of belief and religion, and then also the right to fair labor practices. This is a very wide one, but our labor laws give effect to the broad right to fair labor practices. It's to be noted that all of these are individual rights. It says everyone has got the right to freedom of bodily integrity. And the question is, how does this weigh up against the good for the society? Next slide, please. Now, there can be no doubt that placing an obligation on workers to vaccinate and also to force them to stay at home and having limitations on their travel arrangements, those would be contrary to the fundamental principles contained in the Constitution. However, our Constitutional Court has not had the privilege, if I can call it that, to make a final decision on whether an employee who was dismissed for failing to take a vaccine, whether that would pass constitutional muster or not. We have had other decisions though. And the first of those that I want to touch on to is Mohammed versus President of the Republic of South Africa. During the strict lockdown period, congregants were not allowed to go and pray in their own congregations. Muslim priests took the disaster management restrictions to court, and the court held it is reasonable and it is fair to limit the right to freedom of religion, and the lockdown restrictions were not set aside. Going further, it is now almost 2 years on, and things have changed. South Africa's state of disaster was lifted 2 weeks ago, 4th of April. We don't have any disaster management legislation in place anymore. However, employers have already started implementing measures. And the question is now, what is the current situation in South Africa? Let's have a look at the legal principles. There's a common law duty on every employer to implement safe and, as far as possible, risk-free working environments. If they don't do that, court action may be mounted against them, and they run the risk of having to pay up for fellow employees who may have contracted and even may have been hospitalized and may even die should they contract it at the workplace. The Occupational Health and Safety Act, this legislation has also been in place for many years before the COVID pandemic, confirms this duty of employers to establish safe working conditions. Now, in terms of this Occupational Health and Safety Act, directions were published in South Africa, covering the aspect of how to deal with workers at the workplace and what may employers not do at the workplace. And this is the basis upon which many employers did ultimately implement a vaccine mandate. The Occupational Health and Safety directions provided, amongst others, every employer must do a risk assessment. If the workers work in close proximity of each other, and if they also have customers with which they have a contact, well, then those employers must do a risk assessment and see how they can limit the risks. After consultations with trade unions, after doing a proper analysis, it is possible for an employer, and one could actually say it would be prudent and responsible of an employer to implement a vaccine mandate, to compel all workers to get the vaccine mandate. But we've got other labor laws. The Labor Relations Act protects workers against unfair dismissal and unfair labor practices. If an employee is unfairly dismissed, and that would now mean if there's no fair reason and a fair procedure was not implemented at the workplace itself, this worker could go to the CCMA, it's a tribunal, or the labor court, and even be reinstated or get compensation. It could be, if it's automatically unfair dismissal based on a discrimination, it could be 2 years' salary. Now, let us have a look then at the early cases that were handed down, dealing with employers who did implement COVID vaccines and who did take steps against their employees. Next slide. I'm only going to cover 2 cases. In the Escort case, an employee was a butcher, contracted and tested positive for COVID, did not inform the employer, went back to the workplace, and amongst others, hugged colleagues, greeted them by hand, and only after that the employer found out that the employee was COVID positive. The employer dismissed the worker on grounds of misconduct. You see, a number of the employees had to go away from the workplace and had to self-isolate due to the contact with Mr. Mogotsi. The CCMA initially held it's unfair to dismiss the worker because the disciplinary code did not include the issue of COVID-19 transgressions. However, the Labour Court overturned this and said it was only rational, and that despite the absence of this guide, the disciplinary guide, it's not like a law, the disciplinary guide at the workplace, it was fair to dismiss the employee. The next case, the RISA, we can also refer to it as the Gold Rush case. Here, the employer implemented model COVID-19 protocols at the workplace. The employee objected to vaccinate due to the bodily integrity in terms of the Constitution, and the employer dismissed the employee on grounds of permanent incapacity because the employee said, I will never go for such vaccinations. Here the CCMA held that it was a fair dismissal based on the recognized ground of incapacity in terms of the Labour Relations Act. I've only got a minute or so to go. So looking at the way forward, the national state of disaster has been terminated. This resulted on the Occupational Health and Safety Act directions being terminated. However, amendments have been made. COVID-19 has been recognized as a hazardous biological agent in terms of the regulations. And hence, employers must still do the risk assessments. They're still allowed to implement policies at the workplace. There's actually a duty on them to do so. And this may include even aspects covering the issue of compulsory vaccination. Over to the next slide. We have also now got a code of practice managing the exposure of SARS-CoV-19 to in the workplace. And this regulation, or this code of good practice, will be used as a guide whenever any of our labor laws are currently being interpreted. So in conclusion, the Occupational Health and Safety Act, read with the HBA regulations and the code, does provide a legal basis for an employer to implement the vaccination requirement at the workplace. However, it is not a one-shoe-fits-all approach. It depends on the particular workplace whether it will be justifiable to implement such measures. So on that note, thank you for the opportunity and welcome if anybody has got a burning question. Otherwise, that will be covered at the end of the seminar. Thanks.
Thank you, Professor Vanek. I picked up during your presentation that it is really a very delicate balance between individual rights and then also maintaining the a safe working environment. And I think also for employers, something critical that you did mention is having risk assessments being done. And then also coming up with policies which would sometimes factor even that vaccine mandates. But really risk assessments is something that I really picked up heavily in terms of what you have said. And it would really operate workplace to workplace. It's not really, as you said, one size fits all for everybody. At this point, I don't see any questions on the chat, but if you have any questions really related to that wonderful, brilliant presentation, please do pop it into the chat box and we can still have the discussion later on into the webinar. Now, next in terms of presentation, we have a wonderful presentation from Khemila Narraidoo, who is a practicing lawyer in Mauritius. And as Claire had mentioned earlier on in the webinar, Mauritius will be hosting us for the African Labour Law Conference next year. And she will be one of those who will be hosting us in that beautiful country. Khemila is an employment lawyer and her clients range from Mauritian conglomerates to international companies. She regularly chairs disciplinary committees and acts in relation to employment litigation and dispute resolution before the Supreme Court of Mauritius and the Industrial Court of Mauritius, and also the Conciliation and Mediation Commission. Khemila also conducts litigation before the judges in chambers with regards to applications for summary judgments, and has quite a wealth of knowledge with respect to employment and labor law from Mauritius. She has participated in previous conferences that we have, and has also been a very great resource within that country. And now I would like to welcome Khemila to give us a presentation with respect to what is being practiced in Mauritius.
Thank you. I hope you can hear me correctly.
Yes, we can.
Great. Good afternoon, ladies and gentlemen. It is quite a challenge now for me to speak just after the professor, especially about such a hot topic, if not to say a controversial topic, which I believe will stay hot and controversial for a while to come now. So let me dive straight into the topic of whether there are any laws or regulations mandating vaccine as a condition to return or to continue to work. Currently, there are no Mauritian laws or regulations that directly impose on the employees a general obligation to be vaccinated in order to return or continue to work. I believe what is important is for us to ask ourselves whether it is actually legal for an employer to restrict access to the place of work solely to employees who have taken the COVID-19 vaccine. In order to be able to analyze the intricacies of whether an employee can restrict access to its place of work solely to employees who have taken the COVID-19 vaccine, I believe it is also apposite to firstly look at whether there is currently any legal requirement to be mandatorily vaccinated against the COVID-19 virus in Mauritius. Basically, except for a list of places, institutions, and premises to which access is restricted under the law for the moment, and we will look at further in a minute, there is currently neither any local legislations nor any government measures which makes vaccination mandatory, leave alone other place of work. Currently, there is no Mauritian laws or regulations that directly impose on the employees a general obligation to be vaccinated in order to return or to continue to work. Employees are allowed to return or continue to work even if they are not fully vaccinated. So the question which arises under the Mauritian jurisdiction is more whether there are restrictions in place for employees to have access to their place of work. For us to be able to tackle this question, we would need to look at recent legal amendments which affected directly and indirectly our public and private sectors. Let us first look at the public sector, and for us to be able to do that, we will need to look at the regulations which have been issued under our Quarantine Act. Regulations under our Quarantine Act, basically, I think on the 21st of June 2021, the COVID-19 restriction of access to specified institutions, Regulations 2021, were enacted. These regulations used to apply solely to educational and medical sectors in Mauritius. According to this regulation, access to what we call a specified institution was restricted to someone who could either present his COVID-19 vaccination card, or if the person has not been vaccinated, with a COVID-19 vaccine, the person has to present a PCR test result slip in the form prescribed by the regulations, certifying a negative result dating back to not more than 7 days from the date that the PCR test was undertaken. The person could also provide a certificate certified by a panel of 2 government medical officers that he cannot be vaccinated for different reasons. So let's say for this kind of certificate, for the purpose of this webinar, I would be calling this the medical certificate. Basically, currently in Mauritius, our international borders have now reopened last year as from the 1st of October 2021. And we can see that since this awakening step, the government has added many more specified institutions, places, and premises to the educational and medical sectors, in addition to the medical and educational sectors. The COVID-19 restriction of access to specified institutional regulation have now been repealed and been replaced by the Consolidated COVID-19 Regulations 2021, which have been issued under the Quarantine Act. So the 5th schedule to this includes around 32 different categories of specified institution. I am putting emphasis on this because I will point this out later on. So we know that the government is increasing areas where it is essential to put in such extreme safety and precautionary measures, and not just issuing a general law preventing access to unvaccinated employees to their place of work. This raises the question of whether this is a disguised way to restrict access to place of work. Now, when it comes to having access to these categories of specified institutions, the employees would have to abide by the strict restrictions of, as I mentioned before, vaccination card, PCR test result, or the medical certificate. At this point, I believe it is important for me to also highlight the fact that the law has recently been amended to specify that when a person is presenting his vaccination card, the vaccination card should show that the person is fully vaccinated. Now, this is new under our law since the beginning of this year, in as much as for a person to be considered fully vaccinated, the person must have had his booster dose, which is actually the 3rd dose of the vaccine against the COVID-19. This is a further restriction which has been added and which makes us think that the question is maybe no longer whether to be vaccinated or not, but instead that we need to have all 3 doses in order to be able to have access to place of work, especially in the public sector. Now, let us turn to the private sector. In the private sector, no such straightforward laws have been issued. But when we look at the specified institutions, which I have mentioned previously, we know that there are places like restaurants, hair salons, cinema halls, etc., which have been added to that list. Therefore, I believe that in an indirect manner, the law is imposing on the employers in the private sector to restrict their place of work only to people who are fully vaccinated or have a PCR test or the medical certificate. We can see an indirect manner of imposing the restriction to the place of work only to vaccinated persons, even in the private sector, through the government. In the private sector, you will also have those institutions which do not fall under those lists, and therefore we will turn to our labor laws in Mauritius. Because nonetheless, all employers are required by what we have is the Occupational Safety and Health Act 2005, which we commonly call the OSHA, to provide and maintain, so far as is reasonably practicable, a working environment that is safe and without risk to health, and to ensure that no person is exposed to such risk. The test is laid out under the OSHA is for the employer to take measures which are reasonable. Now, the burden would be on the employer to show that the safety and sanitary measures which the company has put in place are reasonable. Now, we all know what a large definition can be given to the word reasonable. And I'm sure, just like in Mauritius, in many countries, the actual definition to be given to the word reasonable is left to the fine discretion of our judges. So the main question which arises at this stage is whether the employer can take such drastic measures, such as limiting access to the workplace solely to employees who have been vaccinated, and doing so without infringing the rights of the other employees who have not been vaccinated, and without such measures being considered as unreasonable. In the light of these changes, although my perception maybe last year was that I believe that it would be difficult for an employer to show that limiting access to the workplace solely to employees who have been vaccinated is a reasonable measure to ensure a safe environment without infringing the rights of the employees. I believe that it was going to be very difficult for employers to do that. But however, with the advent of the increase in specified institution, change in the definition of fully vaccinated, my opinion is that we may slowly but surely going towards a phase where an employer in the private sector would be able to make it mandatory for an employee to be fully vaccinated or have to have his PCR test result or the famous medical test to be able to have access to their place of work. In this respect, questions have also arisen concerning the legality of the COVID-19 regulations. Basically, at first, the regulations were supposed to enter into force on the 21st of June 2021, and were supposed to come to an end on the 31st of August 2021. However, we know that the regulations are still in force and have been amended multiple times. On top of that, the list of specified institutions is constantly subject to additions. At first, only, as I mentioned, there was only the educational and health institution. But now the list has been extended to around 32 institutions, including airports, police premises, restaurants, hotels. So as a matter of fact, there are very few institutions which are not part of this list at the moment. So I believe the question, and maybe that we need to ponder, is that there is an indirect general obligation to be vaccinated in order to return or continue to work. So I like to look into infringement of employees' rights. So when we turn to our labor laws, one has to ask the question as to whether the implementation of vaccine, I believe you have gone too far in my slides. You will have to, one more. Yeah, that's fine, thank you. And whether the implementation of vaccine mandate would be discriminatory, as I was saying. So apart from the fact that there is the possibility that there may be an infringement of the constitutional rights of an employee for the employee to be vaccinated in order to be able to have access to his place of work, I believe there are certainly an element of discrimination that you need to take into consideration. There are two types of categories of employees. That is, firstly, those for whom it is safe to have the vaccine, but the employee refuses to have the vaccine. And then you have the second employee whose medical conditions prevent him or her from taking the vaccine. Let us look at the situation where the employee in question wants to have the vaccination, but cannot do so because of medical conditions. For example, the employee is pregnant. So far, the World Health Organization is still carrying out studies and tests to examine the safety and efficiency of COVID-19 in children and pregnant women. So in the case of a pregnant employee, she would not be vaccinated. Let's say she does not want to be vaccinated and would not be able to have access to the company's place of work. As such, we should turn our mind to the provisions underlining discrimination in employment law under our Section 5 of the Workers' Rights Act, which, as you will see, I have reproduced in the slide. So, and you will see I have underlined a pregnancy in the slide. So in the light of these sections of the law, it can be inferred that by denying access to the place of work to a pregnant person who could not be vaccinated due to her pregnancy, the employer would be affording a different treatment to the said employee. This may be interpreted as discriminatory against the said employee. On the other hand, I think this is found in my next slide, you would have Section 5 of our Workers' Rights Act, which also provides that a person does not discriminate against another person by imposing or proposing to impose on that other person a condition, requirement, or practice that has or is likely to have a disadvantaging effect where the condition, requirement, or practice is reasonable in the circumstances. We may reach a situation where imposing a vaccination mandate on employees against regarding the COVID-19 outbreak situation, which can be considered as a reasonable in the circumstances. Hence, I believe it is debatable that by allowing solely vaccinated employees to its workplace, the employer will be deemed to have excluded a certain group of employees and may be held liable for having acted in a discriminatory manner against a category of employees pursuant to our Workers' Rights Act. Let us turn to international and constitutional laws. So basically, based on formal and informal communiques, as well as the new laws which I have mentioned, we know that the government of Mauritius and its authorities seem to be very favorable to the implementation of vaccine mandates. As such, well, as I just discussed, however, this may make us consider that there is an indirect obligation to be fully vaccinated in order to return or continue to work in Mauritius. Now, this situation has been criticized by several organizations and by the vast majority of people, especially because of the risk of criminal sanctions, which are included in those regulations in case of violations of the regulations. There are views that the COVID-19 regulations may clash with our labor laws as well as our constitution, more precisely Article 3 of our constitution regarding the protection of fundamental rights and freedom of the individual. So concerning a potential violation of the human rights by the Mauritian COVID-19 regulations were also raised by several international associations, such as the Amnesty International. You will see I have put the reference on the slide so that you can have a read through. We may also consider the Commonwealth Human Rights Initiative, CHRI, which is an international NGO that advocates for the promotion and protection of human rights in the Commonwealth. Basically, numerous African countries are part of this NGO. So following this, we may also want to pay attention to the Commonwealth heads of the association declarations, including the 1991 Harare Declaration and the 2007 Kampala Communique. I believe all this, we need to remember that the CHRI have constantly reaffirmed the commitment of the Commonwealth to the advancement of fundamental human rights as a core political value of the Commonwealth. I believe taking all this into consideration, I know we all talk about the new normal, but I think it is important that we be very careful in our next step, in as much as whilst trying to our best to adhere to the new normal, that we don't breach and infringe any of our fundamental rights. Thank you.
Thank you very much, Khemila, for that. I've seen in terms of your presentation, key highlight points are across most of the African countries with respect to vaccine mandates. And I've also seen a general move specifically within the public sector in terms of having those mandates there, but then not having a direct regulation for the private sector. And you gave very good examples in terms of how indirectly some how these mandates do come about, and also your discussion in terms of the balance of individual rights, and then also the public, the good of the public in terms of how we are managing the pandemic. Thank you very much for that. I hope there'll be a lot of questions coming out of from that end in terms of your presentation. Again, I remind you, please drop something in the Q&A in the chat. I see already a few comments. We'll go through that at the end of the webinar. Next, in terms of presentation, we have Rethabile from Lesotho, a very beautiful country indeed. This is Rethabile Sakoane, and I did have to ask her how to properly pronounce it, because they always have very beautiful names, but sometimes a tongue twister for me. But yes, that's where we were able to at least engage. Rethabile is a founder and executive director of Tharollo Consulting, a labor law and human resource management consultancy. She is also the president of the Lesotho Labor Law Society, and she advocates for, and then also an advocate, and has educational qualifications in labor law and human rights, and has been in the practice for an expansive period of 28 years. Rethabile has worked in the government, in the Ministry of Labor and Employment, and then moved to work as a human rights activist in the NGO sector. She has then took over, she then took time teaching at the National University of Lesotho full-time, which she continues to teach also on a part-time basis currently. Her human resource experience was gained from working as a director of the human resources in the mining sector until she decided to run the consultancy on a full-time basis. Welcome, Rethabile. Kindly share your insights from Lesotho.
Thank you, Georgina, and thank you to the African Labour Law Society for hosting this very hot topic, as has been said before. I'm going to present the position in Lesotho in as far as vaccine mandates at the workplace are concerned. I think it is important just to mention that it's good that the professor and Khemila have already mentioned some areas relating to the constitutional provisions and the labor law provisions in their own countries. And even in Lesotho, we have similar provisions, which, are you not able to share, Claire? Or is there a problem? Okay.
Just give me a second. I am changing the slides.
Anyway, let me just
carry on and I'll try again.
Okay. In Lesotho, the management of COVID-19 has mainly been not according to labor laws, but in terms of the public health laws. We have the public health order of 1970 that we will look into as we move along. But I think it is also just to take over from what Khemila has just said, that some of these provisions in terms of the vaccine mandates may have constitutional provisions, the issues of discrimination, non-discrimination, the issue of labor laws. In our labor code, there is a provision on non-discrimination, and these are some of the issues that have come up, as we'll see later in the presentation, that litigation has already started in terms of the constitutionality of the regulations that have already put in place. But anyway, just as a background, as we all know that the COVID-19 pandemic hit the world around December 2019, when we got that information that the Wuhan Municipality Health Commission had declared that there was a flu-like pneumonia, a viral pneumonia that had been discovered. And since that time, the world's changed. I think it's safe to say that we don't anticipate seeing the world in a normal way that we used to see it before December 2019. Now, the first case of COVID-19 in Lesotho was reported on the 30th of May, 2020. Now, this is where after March 18th, when the then Prime Minister had declared a state of emergency and a national lockdown, because already at the time, generally in the world, it was already seen that the pandemic was gaining momentum, and despite the fact that we had not yet recorded a case of COVID-19, but the state of emergency was declared on the 18th of March. To date, we have recorded 32,968 cases of COVID-19, and we have confirmed 697 deaths from the disease. While the death rate was not as high as in many countries, but the effects have been felt throughout the country, psychologically, physiologically, economically, sociologically, and otherwise. So it was at the lips of many Basotho that maybe government should look into getting a vaccine, because already people were starting to talk about the possibility of a vaccine. And a lot of citizens were already saying government should take the responsibility of ensuring that it secures or it sources the vaccine for Basotho. Now, through the World Health Organization, the government of Lesotho was able to source the vaccines. We have now so far been able to source at least 4 types, if I'm correct, 4 types of the vaccine: the AstraZeneca, the Pfizer, the Sinopharm, and the Johnson & Johnson vaccine. And about 780,000 Basotho have already been vaccinated, including school children. Now, this is most of these vaccinations that we're talking about here on the 780 are the first dose. It was only last week when the Minister of Health indicated that they are going to source more vaccines so that Basotho could have access to the boosters. Obviously, as we can understand, it's just the first booster. We still have to go for the second and the third boosters to be fully vaccinated, from what the WHO has already indicated. So that is the situation at the moment. People still continue to get vaccinated, whether it is because of being forced to do so, or it is because of at their own volition. But there is that trend. Around 32% of the population has already vaccinated. We're hoping for more as time goes on. Now, in terms of the laws, as I said earlier, we have the Public Health Order of 1970. We have the Disaster Management Act, and then we have the COVID-19 Risk Determination and Mitigation Framework. And from there, we now have quite a number of amendments to the regulations, as we'll see when we move ahead. But maybe I should also mention that in Lesotho, the National COVID-19 Secretariat, commonly referred to as NACOSEC, it does not refer to vaccine mandates as a vaccine mandate. They're called individualized health measures. So basically, it is just a term that we used in Lesotho as against vaccine mandate, just it's the same, but it's just to address the individual mitigations with regard to management of COVID-19 per individual. So they're called individualized health measures. Earlier this year, the most important, I think, in terms of this topic, regulations that were issued with the Public Health COVID-19 Risk Determination and Mitigation Measures, Amendment number 10 of 2021. And these are the regulations that actually presented the amendments relating to how and when people should be vaccinated. The amendments started at subsection 20 up to 27 of the regulations, and this is where the regulations clearly indicated that a person who is in accordance to Schedule I, and this is now Schedule I of the main framework, identified under the category of persons who are required to be vaccinated by a health vaccinator, nurse, or medical practitioner shall not engage in work, perform duties, provide or acquire services at any institution or place of work, study, or business unless the person has received at least one dose of an approved COVID-19 vaccine. And secondly, the person has received or has evidence of a booking to receive a second dose of the approved COVID-19 vaccine within 2 months of the first dose. This is now when the government decided that it was going to ensure that all persons, for them to get access to services, whether it's health services or any other services in any institution, whether public or private, they have to show by proof that they have been vaccinated. Now it goes on to provide that even children between 12 and 17 years were now required to vaccinate, and parents and guardians were now mandated to ensure that such children were vaccinated. Which would mean that without vaccination, they should not, or they would not be allowed to have access to learning facilities. They would not have access to their schools because they have not been vaccinated. Now, the vaccination card was introduced by subsection 22, which now says that all persons, vaccinated persons would be required to produce a vaccination card. And that card has to be signed by a legally qualified and licensed medical practitioner. Last weekend, it was a bit of a havoc at the border post because people now wanted to cross to South Africa, and most of them had vaccination cards as the law requires. But apparently, the South African officials needed something more than just a vaccination card. They needed a vaccination certificate. So it now needed further production of a vaccination certificate, which can now easily be produced from a system that the government has put in place, an online system where you can print out your vaccination certificate to be able to cross into South Africa. Otherwise, you still have to get tested at the border if you don't have a vaccination certificate. Now, subsection 23 of those regulations now provided for exclusions to the mandated vaccination. It provides for production of a medical certificate issued by a medical practitioner that a person is not able or cannot be vaccinated because of a medical condition. And the medical practitioner has to indicate the nature of the condition he has to mention the nature of the medical condition. That exemption also has to be signed by the Director General of Health Services to endorse the exemption. So basically, it means that the only people who have been exempted from vaccination are those that can produce a proof of a medical condition and nothing else. So as we mentioned earlier, in terms of discrimination, a lot of people were now arguing or are still arguing that it is discriminatory if people cannot be allowed not to vaccinate because of any other reason except the medical condition. Then it obviously says you're not considering other reasons that people can put in place or can present for them not, or to decide not to be vaccinated. Now, subsection 24 of the regulations also now talk about production of a vaccine certificate upon request by the chief accounting officer, manager, or an owner of a business, owner of or a person in charge of an institution or enterprise. This now says when you get to a workplace, or you get to an institution or to a business entity, the owner of that place, or the chief accounting officer of a public institution, or a manager of a company is now given the right to demand for the person approaching seeking services to produce a vaccine certificate as proof of vaccination. Now, failure to produce such a certificate was regarded as, actually, it says the public officer, or the public health officer, or the law enforcement officer is now given the right to direct the person who is not able to produce a vaccine certificate to do such things as are reasonably necessary to comply with the sub-regulation. It is not really clear what these such things that are reasonably necessary to comply with the sub-regulations are, but there was that provision saying that the public officer, or the public health, or the law enforcement officer could then direct the person who is not able to produce a vaccine certificate to do such things as are necessary to comply with the sub-regulations. Subsection 26 of the regulations also provide or places a responsibility at the doors of the managers and chief accounting officers to ensure that unvaccinated people do not enter or remain or provide or receive services at the premises. It was now incumbent on the managers, on the chief accounting officers, the people who are responsible for such institutions, such workplaces, to ensure that a person who seeks to receive services from their institutions, or who provides services, is vaccinated, and they do so by ensuring that they do have the vaccine certificate as has been indicated. Now, they were also now required to keep a register regarding vaccination, the status of vaccination of their employees. And such register was supposed to be kept at the workplaces, so that should a public health officer or a law enforcement officer require to have a look at, then they would be able to produce it. These regulations have received a lot of uproar and outcry from some sections of the population, as you can imagine, mainly the religious sectors, and those people who are saying, human rights activists who are saying, maybe government should have considered approaching this in a different way. Like in South Africa, as Professor Van Eck has already indicated, there are other means in which you can coerce people to get vaccinated without necessarily forcing them to vaccinate, but you can nicely coerce people to self-regulate and ultimately decide on their own to get vaccinated. Just recently, there has been an amendment to these regulations, where I think it is regulation number, amendment number 15, where now the government has indicated that for a person, before a person can be vaccinated, there is now provision for counseling, where an individual may be given pre-vaccination counseling, so that they can decide on their own whether they want to be vaccinated or not. What confusion this may bring is whether now, if after counseling a person decides that they do not want to be vaccinated, does that mean that they could be allowed to continue with business as usual as if vaccinated? In my view, no. The idea is that all people still need to be vaccinated. It does not mean that after receiving counseling and deciding not to get vaccinated, then you will be treated as if vaccinated. You would still be denied certain services in some places because of being unvaccinated. So in terms of litigation, we currently have one case that is in the courts of law, in the Constitutional Court, It has not yet been decided. We are still waiting for judgment. But these cases started off as 2 cases, but the lawyers decided to consolidate them into one. It is a case of Christian Advocates and Ambassadors Association and others versus the Prime Minister of Lesotho and others. This is a case where the applicants have challenged the constitutionality of the regulations, the public health regulations, and they have mentioned quite a number of issues where they are saying it is wrong for the government to forcibly demand that citizens should be vaccinated. Some of the issues that they have raised are that the vaccine itself that contains unknown ingredients, which it's not very clear how they are likely to affect humans. And it also raises that issue of discrimination of the vaccinated against the unvaccinated citizens. They have also raised an issue of post-vaccination deaths, which were yet to be determined whether in actual fact there are any post-vaccinations or post-vaccination related deaths. Now, there is also an element of having to go through the several doses for an individual to get fully vaccinated, and they are saying that is also very unfair to the citizens, that they should be subjected to so many doses before they can be declared as fully vaccinated. And they also have mentioned that the COVID-19 itself has the regulations have an international origin, which actually should have been domesticated first through the 2 houses of parliament without necessarily now implementing and forcing them upon citizens, even as if they are laws that have gone through the normal ways in which laws are promulgated in the country. So this is a case that unfortunately we can't even get deep into it because we're still awaiting judgment, but these are some of the issues that have been raised, and some members of the Basotho community are really looking closely, following it very closely, because in their minds they are of the view that this case might actually bring some clarity in terms of whether it is constitutionally correct that the government is forcing people to vaccinate. Now, I also had occasion to discuss this issue with social partners, mainly the organized labor and organized business. And in their view, the employers are of the view that they would really have actually promote that all people should be made to understand that it is important to vaccinate, and that should be done in other ways rather than forcing people to vaccinate. But obviously, they also say they have a right to exclude anybody entering their premises or seeking services from their premises if they have not been vaccinated, as the regulations provide. They have also indicated that, unfortunately, the forcing of the vaccination is likely to affect production, in the sense that if you have a factory, in a factory where you have a whole line of employees who have not been vaccinated, obviously that would mean that the manager of that workplace would have to deny those employees access to the workplace. That would mean it's going to affect production, and they would advise against that. So theirs is just to make sure that they do promote vaccination, ensuring that people do get vaccinated. But they are saying maybe the way it was, we went about it was a bit drastic to the extent that it could not be very much effective. However, they did indicate that in most workplaces, employees are voluntarily going for vaccinations, and they do get vaccinated. The trade unions, on the other hand, were also of the view that in their mind, it goes without saying that, you know, everybody must be vaccinated. They have to be vaccinated, but they are also same mind as the employers, that maybe the forcing, the mandating may not be correct. They did indicate that, particularly in the education sector, they talked to the teachers, they advised, they counseled teachers to do get vaccinated, seeing that they were the most vulnerable in terms of access to this virus, and they are saying that they did not have a problem of getting voluntary vaccinations without necessarily having to force people to vaccinate. But they're also saying that maybe government should also consider involving, or at least including, social partners when such decisions are made, because they are better placed as organized labor and as organized business. They are better placed to know the needs and the circumstances and the situations of their constituencies. So it would have been better if they had been consulted before the regulations were drawn up, so that they could have some advice as to how to approach the situation. But generally, I think the feeling is the same, that people do really need to get vaccinated, and that should be promoted as much as possible, using other means other than the mandates. Now, lastly, I think it is important to mention that our labor laws have really we haven't really done much in terms of any provisions of the labor laws with regard to COVID-19, any new regulations relating to COVID-19. We're still working under the same occupational safety and health regulations, which are still provide for the responsibilities of the employers and the employees with regard to keeping workplaces clean, safe, and healthy for all employees and service providers and clients. So we still would need to make reference to those should there be a need to do so. In terms of the labor code, as I mentioned earlier, those principles of freedom from discrimination and the constitutional provisions, those still stand. But there hasn't really been much changes in terms of the COVID-19 pandemic ever since that year when COVID-19 started. So generally, we've been working on the basis of these regulations, the framework, the risk and mitigation framework, and the regulations that I have mentioned herein. I think I can stop here for now.
Thank you very much, Rethabile, for giving us insights quite a bit from Lesotho. Some of the things I picked up, Aria, was that there's been I would say very strict enforcement to try and get to have the vaccine mandates. But even as much as there's that need to have citizens vaccinated, and there also are the strict guidelines and measures towards that, there's also been that approach in terms of also softening how you try and get those vaccinations done. I picked up, instead of using the word vaccine mandates, it's individualized health measures. So you're still giving the power to the person to actually make that decision by making it is yours. Whether that practically actually happens, that's another thing, but then just softening the words. There's also the element of encouraging also sensitization and also counseling even before you get the vaccination, which are good strides towards that. But then I've also noticed that even in your presentation, you did make reference quite a bit to the vaccine certificates, which in quite a number of jurisdictions have literally become our new IDs. So if you don't have that vaccine certificate, you are restricted to certain access in terms of the public sector access to services that you should have as a right. And this certificate is now looking at is superseding any other document, even in terms of travel. So it will be very interesting as we do the discussion at the end of the webinar, what will come out of that, and also questions based on that presentation. But thank you very much, Rethabile. Now, the last presentation will be from Dudley Ochiel from Kenya. Dudley is a constitutional lawyer and advocate of the Supreme Court of Kenya. He is author and co-authored of numerous articles on the Constitution and constitutional rights. He is also a passionate activist for the rule of law, and he is a litigation and legal researcher for Katiba Institute and has previously been a legal researcher at the National Council for Law Reporting. Dudley's presentation will be leaning quite heavily in terms of the aspects of constitutional law and constitutionality with respect to these mandates, and also having an international perspective towards that. Dudley, you may proceed. Thank you.
My friend, Mr. Ogoso, who is in the audience, must be wondering when I left him as an advocate of the High Court and became advocate of the Supreme Court. I meant Supreme Court regular. I've argued a lot of cases there and go there frequently. There's a slight difference. In Kenya, like all the other countries, there have been attempts to enforce mandatory vaccination. There's no law that directly regulates this issue, the issue of COVID-19 vaccination. But the government has made 2 attempts to make vaccination compulsory. In June last year, the government issued a circular through the head of public service directing all government employees to get vaccinated. Then in December, around November, December, the government, now through the Ministry of Health, issued another circular, this time saying that if you are unvaccinated, then you have no right to access government services, and you should also be kept away from other public amenities like supermarkets. Both of those have been challenged in court. There's a court order staying both circulars, and the matter has a hearing date in June this year. So far, the circulars are not being enforced because of the conservatory orders given by the court. What are the laws that regulate this area? First, if you look at the Public Health Act, Kenya's Public Health Act, it's an ancient legislation. It goes back to the colonial period or just right after it. It gives the Minister of Health a lot of powers to order the vaccination or revaccination of someone. And it empowers the minister to make rules for vaccination. Section 107 of that act provides for the exemption. I had similar language, I think, from Lesotho, where a vaccinator or public health officer or other medical professional is of the opinion that someone is not in a condition to be vaccinated, then they're exempted for 6 months, which recurs until that person is eventually vaccinated using reasonable effort. And when the government tried to enforce mandatory vaccination and the cases were filed, one of the claims was the issue of religion, that this mandatory vaccination violates the right to conscience, to choose. The other claim made was on the question of privacy. And when it comes to the constitutional angle, there's the 3-part test that applies to all limitations of rights. Because besides rights like torture or fair trial or the right not to be subjected to slavery, all other rights under the Constitution of Kenya can be limited. And there's a test, the 3-part test. The first part of that test will ask the question, was this by law? Was it done by law? And the court would have to consider whether a government circular amounts to law, or whether the circular is precise enough, because when a norm is vague, then it is not law. especially if it has punitive effects. It must be crafted with a lot of precision for it to amount to law. And if the circulars pass that test, the first bit of the test determining the legality of that circular, then we go to the next step, which is legitimate aim. And the question would be, in a pandemic, is there a legitimate aim for the government to want to have everyone vaccinated? If the question is framed that way, then it would appear as if the mandate would pass the second test. And that would take us to the third angle, which is the proportionality limb. And the question would be, is this strictly necessary? Is it strictly necessary to require everyone to be vaccinated? And supposing the answer to that is yes, then you would turn to the other question, which is this the least restrictive measure? Even if a measure is necessary, but the other less intrusive options, then it would not be proportionate to pick that measure when there are other options. It would fail the test of proportionality. So if that last bit of the three-part test is also answered in the affirmative, then the court will be likely to uphold the mandate. The question then becomes, what are social partners saying about this? What is the labor movement saying about this? Interestingly, there's been silence, stoic silence in the labor movement in Kenya on these cases. One of the cases named the Federation of Kenya Employers as an interested party, but FKE has not filed anything in the court case where it was named as an interested party. COTU has not offered to assist the court or tried to engage as an interested party. COTU is short for the Confederation of Trade Unions in Kenya. It's the biggest umbrella body in the labor movement. It has also not said anything about these cases. So there's been silence from the labor movement about the question of mandatory vaccination. In a word, that is a situation in Kenya about mandatory vaccine or the vaccine mandates. I would stop there and wait to answer questions, should there be any. Thank you so much for the time, Georgina.
Thank you very much, Dudley, for that. I think taking from your brief presentation is that are government circulars sufficient enough to create a vaccine mandate? And how far can somebody go, or how far can the government go in terms of enforcing that just based on those circulars, aside from just even the public sector, specifically in the private sector? Maybe you can just address that before we go on to maybe the Q&As.
I think the straight answer would be no, for 2 reasons. One, the Act talks about the cabinet secretary. The first circular calling for mandatory vaccination of government employees was issued by a gentleman who holds the office called the head of public service. So straight away, it was not issued by the correct authority. And also, for a measure to be law, it needs to be publicized, must be gazetted, for example. It would be sufficient, in my view, if the measure was brought about in regulations, which are gazetted and now have the force of law. It would appear to me that a government circular might not have the necessary force of law to amount to law, to be a norm that has a force of law. Unless maybe the statute already provides that the government would issue a circular so that it then becomes a statutory instrument because it's issued under the direct authority of a statute or of the Constitution. But for a circular just issued without any statutory underpinning to it, I don't think it would meet the test of law, measure made by law.
Okay, and then with respect to now having those laws in place, and I'm asking this question from both a legal and also practical perspective. What would your opinion be in terms of having that effect if we were to push for those vaccine mandates? What would be the best way towards that?
I think it would have to be under the Public Health Act, because that is the one that says that the Cabinet Secretary will make for vaccination and revaccination. And it has so many provisions where there's an infectious disease. It empowers the minister to make rules requiring the vaccination of anyone coming into Kenya. So it has ample room for play within the Public Health Act. My view is that the way that first circular was issued was outside the law, and I think the court is likely to nullify it. Not saying too much about it because it's pending now.
Okay. Thank you very much, Dudley, on that. I know we're still going to have a few questions. I have a few questions under the questions and answers section. I'll go through them and then I'll also go to the chat. I can see some vibrant discussions coming out of the presentations. So I'll just pick on a few of those. I'll start with the first question, and that goes to Khemila, from a question from Mauritius. What happens if an employee is consistently absent from work due to COVID and has used all their sick leave? What options does the employer have? Sorry, Khemila, you're on mute.
IT and me are two different worlds. Can you hear me?
Yes, we can.
I think this question is as hot as the topic, and at one point it was very much talk of the town. Basically, this is very much at the discretion of the employer. When somebody has used up all of his or her sick leaves, in Mauritius we also have other types of leaves, such as the local leaves. Now, it would be completely at the discretion of the employer to decide whether to start taking those leaves from the annual leaves of the person, that is the local leaves of the person. Let's just say in such a drastic and quite dire circumstances, employers have been comprehensive and have accepted to dig out from the lot of the annual leaves. However, I believe most probably that person's next question would have been, what happens if all of the annual leaves and sick leaves have run out? In that case, unfortunately, the employer has the right to start deducting from the salary of the person for the number of days that the person would be on sick leave once that person has run out of all of his or her local leaves or sick leaves. That's
Thank you, Khemila. Prof Barnett, can you give a perspective from South Africa?
Yes, a very similar situation would apply in South Africa. First of all, apply for your different types of sick leave. We've got regulations in our Basic Conditions of Employment Act that regulates when one should apply and what the requirements are for the medical certificate and so on. Doctor booking you off, because there's also a possibility that you would not qualify for your sick leave if you don't fall within those prescriptions. But then when all sick leave has been depleted, the employer, I would think, could inform the employee, well, you're not present, you haven't applied for any form of leave, so you're absent without leave. Then those procedures will kick in. But the employer could, I suppose, also then suggest and say, well, you do still have other forms of leave, such as vacation leave, and you should apply for that. Otherwise, steps may need to be taken against you. I hope that I've picked up the question correctly, though, and
Yes.
but that would be the perspective from South Africa.
Okay, thank you. And then the next question is coming from Pamotent. I am Pamotent. I would like to find out whether in carrying out their obligation to keep workplaces safe, do employers not owe a duty of full disclosure to prospective employees that it is a precondition to be vaccinated to be employed? I'd ask Rethabile, maybe you can give a response to that.
Thank you. I think what we have to understand is that COVID-19 took everybody by surprise. Nobody knew that we would be where we are today. So in terms of the employees who are already in employment, that we can understand there isn't much that the employer can do in terms of ensuring that they do not get COVID or they do not infect others. You know, they're already employees, so it's just a matter of applying the occupational safety and health regulations, ensuring that the workplace is safe and healthy and otherwise for the other employees. But in terms of those who are only joining now, I think I agree with Advocate Ended that we can't avoid not being, you know, having full disclosure to indicate to the prospective employees that COVID vaccination should be a precondition for employment. The question still stands whether we are saying because they are vaccinated, then they will not infect others with COVID-19. That's yet another question. But if they insist that for purposes of ensuring that they comply with occupational safety and health regulations to keep the workplaces safe and healthy, then they would demand that employees be vaccinated. Pre-employment vaccination. I think it's something that will definitely become an issue in the coming periods.
Okay, thank you very much. There's also another question here. Hello, in Mauritius, is it compulsory to ask employees to provide vaccine cards to keep on records?
Hi, no, not necessarily, but I think the question probably is with regards to the fact that, because as I mentioned, so far in Mauritius, it is not yet mandatory to be vaccinated in order to access your place of work, obviously, except for the exceptions that we have mentioned during the presentation. Now, I believe in Mauritius lately, another amendment that has been brought is that when a person takes a day off to go and get vaccinated, that person is allowed a leave to not attend work on that day. Now, employers may want to take a copy of that vaccination card. This is a bit of a midway between data protection and worker and labor laws, actually. But as far as I know, under the Data Protection Act, which we have in Mauritius, you can collect this information from the employee as long as you are informing the employee what you're going to do with this information. And in that particular case, I would have thought it would be to be kept in the file, in the HR file of the employee. So with that in mind, I would have said the employer can keep a copy of the vaccination card in the HR file of the employee. There is certainly no law that says it is mandatory to keep a copy of the vaccination card.
Okay. And in line with the discussion on vaccination card, there is a comment by Martha on the chats with respect to the issue of vaccination cards vis-a-vis vaccination certificates. And I think this was at the time, I think, Rethabile, you were presenting. And her comment is that basically she doesn't think it is fair to be told at the border gate to produce a certificate, not a card. I think the Ministry of Health should inform the public about the travel requirements. This morning I returned from Maseru Bridge to get a vaccination certificate, not a vaccination card. And I've been seeing it across quite a number of the jurisdiction. The whole issue of vaccination certificates have really come up quite a bit. If you maybe you can just give a 1 minute insight on that, Rethabile.
Yeah, I think for our side here, the regulations do mention a vaccination card. They say that, as I said, subsection 22 says, a person or a child subject to the requirements of subsection 20 or 21 shall, after receiving COVID-19 vaccination, be issued with a COVID-19 vaccination card signed by a legally qualified and licensed medical practitioner. However, as it goes on, it also says that I think it is under section 20, subsection 27. They do also mention a vaccination certificate. So it basically says that there is mention of a vaccination certificate, and maybe Martha is correct in the sense that that distinction needed to be made very clear to the public about that, the difference between the vaccination card, because we do have this pink vaccination cards. Every person who has vaccinated has been issued with a vaccination card. And I think a lot of people assumed that that was enough. That is the card that you can produce anywhere, indicating that you have actually been vaccinated. Not realizing that in actual fact, there is a vaccination certificate that you can download from the system. And like I said, there is an online system that government has put in place where you can actually do it on your own. You don't even have to go to the Ministry of Health to get the certificate. But a lot of people were not aware. So they kept going to the borders with the pink cards, assuming that that is what was required, only to be returned at the border gate with a demand for a vaccine certificate. And that vaccine certificate needs to have the necessary barcodes and other security measures. So now people are getting to understand, they're getting to use the system, the online system, where now they're able to download their own vaccine certificates and produce those instead of the pink cards at the border.
Okay, thank you very much. And then I have a question for Dudley, also on the line of the vaccination certificates, because different countries come up with what their requirements are within the country and then also with respect to travel. Would it get to a point where maybe, and I know that it is there are some countries that require vaccination certificate, others don't, that there will be a great imbalance over a period of time in terms of the changing laws with respect to dealing with the COVID-19 pandemic, and then also in relation to vaccination across the globe?
Well, I think, Georgina, that's one of the lessons that we have all learned from this pandemic. There's never been a time when the world was shut down, especially in the modern age. So maybe countries are trying as they go, but I think as we go forward, there would have to be some kind of uniformity in the approach to vaccination or the requirement for vaccination cards for travel.
Okay. Thank you very much, Dudley. And then last off in the chats, there is a question by Advocate Mahapi. Does that mean that failure to vaccinate amounts to incapacity in terms of the law? This, in my view, would not pass the test. The person was not incapacitated on the grounds of health. He was not ill to the extent that he would not be able to work. He had not contracted COVID where he would he would transmit it to others. He was not exposed to either in his home or in social interactions where he could also contract it and transmit it to others. His view is therefore that the employee should not have been dismissed right away, but they should have been given a warning and told to vaccinate if exposure or potential transmission of infection is provided. And I think that comes back to Professor Vanek's presentation in terms of reasonableness and also balance with respect to that enforcement of the vaccination mandates. And then I would say the most extreme effect of it in terms of termination. If you could just give us tidbit notes for us to take home with as nuggets with respect to this, because I know a lot of employers are amongst those participants and are really grappling with this to the extent that some have to even consider, do I have to let go of these employees because of that element?
Thank you. If I can just possibly say one, I didn't have much time to elaborate on the facts and so forth. The employer did an analysis. They consulted the trade unions. Trade unions and the workers were informed that a policy would be put in place. The employees worked in close proximity with one another, and it would not have been possible to split the employees. The analysis indicated that there's quite a possibility of people in fact contaminating each other or rather infecting each other. They've actually also, in terms of that policy, they've got an exemption policy. This employee applied and said, please, on grounds of my constitutional grounds of my bodily integrity, I don't want to be vaccinated. The exemption committee then said, sorry, we have looked at your situation. You work in close proximity of both the public and your fellow employees. That is the type of work that you do. The employer then conducted a hearing. This is not a disciplinary hearing, but an incapacity hearing. And the employee said, I will never take the vaccination. I will never accept it. So there was no chance of a warning that would have changed the position. The employee said, well, it is a principled decision that employee will never take the vaccine. In South African law, incapacity can be both on a physical ground. Somebody could be involved in a motor accident and they can't do the work that they could be wheelchair ridden, or it could be incapacity due to poor work performance. And in this instance, quite controversially so, the CCMA said, well, this is an example of incapacity. I could take the example to, let us say it is doctors and nurses. Let us say this person does that type of work. The employer said, well, I don't have any choice but to dismiss this employee. But it was controversial. It may have been easier for the employer to implement a compulsory vaccine mandate based on, for example, essential service type of work that is being done. And if the employee then doesn't adhere to the principle, then the employer could have dismissed the employee on grounds of misconduct for breaching an employment policy. But rationality will apply. It would not apply to each and every workplace. It depends on the specific type of work and the specific type of workplace before something like that would have been acceptable. But on that note, I'm hoping that that covered that question.
Okay, thank you very much, Prof. I really believe there's always facts behind every decision or every judgment, and you have to also really look at it from a holistic perspective and case by case, because it's really, as you said again, it is not one size fits all in every situation. There's also a question on the question and answer segment from Crispin Bosire. The principle of mitigation of risk requires employers to protect their health interests of the majority of employees who have been vaccinated by availing the alternative workplaces or other systems of working, such as working from home. How feasible are these options in light of the principles such as discrimination? Dudley, maybe you can address this question.
I think the question speaks to the issue of proportionality. if there's an alternative, like working from home, suppose you're running a call center where your workers, all of them can work remotely. I think the vaccination requirements could be different from someone who runs a bank where all the workers, all the employees work in person and handle thousands of customers daily. So I think it will be different from place to place. It could be different from someone who runs a hospital or who runs a school where they interact with hundreds of people daily. That's why we spoke about the proportionality angle. You look at the necessity of that. Is it strictly necessary to compel vaccination for that workplace? And are there alternatives, other feasible alternatives that would lead you to the same aim?
Thank you very much, Dudley. Reviewing both the chats and the Q&As, I don't see any other questions. So I think at this juncture, as we are about to close off in terms of the webinar, I firstly like to thank the organizing committee, that's Claire Fincham, and then it's also Dr. Pamizai Bamu, who is also the president of the society, who was very instrumental in terms of coming up with this topic. A lot of questions came out of our conference last year, which was held in Nairobi, Kenya, but we didn't specifically address the question of vaccination. During the course of this year, as we have our respective webinars, we do address that question, and this is one of the first ones that we will be having through the year. And we really like to thank all the participants. I also like to thank all the presenters who have exemplary represented the positions within their respective jurisdictions and countries. And I think across the respective borders, we can pick up something and learn something which we can apply within our workplaces, within our societies, communities, and also those who are even in government have picked up on something that your neighbor is doing or brother across the border is doing, just to make sure we are all globally safe. And we also respect the interests and rights of others towards that, because I don't think anybody is out here to harm one another. We're in a situation of a pandemic that no one really saw would be coming. Who would have known that we'd have lost a whole year and lost many, many people in the process? But we are now really rebuilding our respective communities and the world at large. And we just need to do that in a safe way. I'd also like to just also highlight that the presentation slides will be shared by Claire after this webinar. And please keep an eye out for future webinars, and we really appreciate the support from all of you and your participation. And we all hope to see you in Mauritius next year. Khemila will be happy to welcome us all there in that lovely country. I am also already gearing up and saving up all my pennies to hopefully get there. So that is also a very good thing, and we appreciate you. Claire, unless you have any parting shot or comment, we can close the webinar.
Yeah, thank you, Georgina, for emceeing the afternoon as well. Thank you, everybody, for joining us.
Thank you. Thank you very much. Have a good afternoon.